All right, class, pens down and eyes front. Welcome to today's explainer. For the KSLU law students joining my lecture today, I need your absolute undivided attention. Today we're tackling a massive topic in family law too, the doctrine of option of puberty, known in Islamic jurisprudence as Khyar-ul-Bulugh. I'm going to be very blunt with you. If you memorize the exact structure I'm about to give you word for word and replicate it in your answer scripts, I guarantee you are going to secure maximum marks. So let's dive into this material with strict examination focus.
Whenever you're tackling a 16-mark long-form question in your university exams, you literally never just start writing paragraphs. You need to provide a clear roadmap. Instruct yourselves right now to write this exact synopsis at the very top of your answer sheet. Introduction and meaning, legal basis, essential conditions, procedure and effects, leading case laws, and finally, significance and conclusion. Setting up this structured agenda is exactly what your evaluator wants to see before they even read a single argument.
Introduction and meaning. When you write this in your university booklets, grab your ruler and draw a double line right underneath it. It absolutely must stand out.
Let's look at the exact legal definition on the board. The option of puberty is the right of a minor, on attaining puberty, to either accept or repudiate a marriage contracted during minority by a guardian. Write that verbatim. To break it down, remember that under Muslim law, marriage is fundamentally a civil contract, and a minor, naturally, lacks the legal capacity to enter into a contract, right? So they might be given in marriage by a guardian, but the law provides a vital safety valve. This doctrine exists strictly to protect minors from forced or unsuitable marriages, handing them the ultimate power to cancel the whole thing once they come of age.
Now notice the phrasing here. I want you underlining the words protective right and free consent. These are the crucial keywords your KSLU evaluator will be scanning for in your introduction. If those words aren't there, your answer lacks jurisprudential depth.
Moving on to heading number 2, legal basis. Shift your focus because we're stepping out of traditional jurisprudence and right into codified statutory law.
As you can see, we've got a duality of law here. This doctrine is recognized under traditional Muslim personal law, sure, but it also has a strict statutory embodiment. Section 2, Clause Roman numeral 7 of the Dissolution of Muslim Marriages Act, 1939. You've got to write both down, but listen to me carefully. Citing that exact bare act provision is non-negotiable for scoring top marks. Evaluators deduct heavily when students vaguely say under the act, it's Section 2V. Memorize it.
Next heading, essential conditions for exercise. I'm warning you right now, missing even one of these conditions on your script will result in instantly deducted marks. The law isn't just a suggestion, it's a rigid checklist.
Read these 4 bullet points distinctly. 1. Marriage during minority. 2. Marriage by guardian. 3. Attainment of puberty. 4. No consummation. When you get into that exam hall, I expect to see these listed in distinct, clear bullet points, exactly like it is on the board. Do not bundle them into a messy paragraph.
Let's really dissect that second condition. The marriage must have been arranged by a guardian. Now, if you want to show the evaluator that you have a profound, nuanced grasp of the different schools in Muslim law, you have to mention this exception. Some schools restrict the minor's right to repudiate if the marriage was contracted specifically by the father or the paternal grandfather. In those specific cases, the minor can only repudiate if they can definitively show actual misconduct or that the marriage is manifestly to their disadvantage. Right now, that nuance? That demonstrates sheer academic excellence.
Then number 15, write it down. Under traditional Muslim law, puberty is legally presumed at 15 years of age. But you must immediately clarify in your answer that under the statutory framework of the 1939 Act, a Muslim girl has the right to repudiate the marriage before attaining 18 years of age. So the absolute crux of your argument needs to highlight that timeline between 15 and 18 years.
Look at this slide, because this is the absolute deal breaker. The marriage must not have been consummated. I want you to underline the word consummation heavily in your notes. If consummation has occurred, meaning the marriage has been physically actualized, the right of Khyar-ul-Bulugh is permanently extinguished, period. We're transitioning to the procedural aspect now. Procedure. How and when can it be exercised? Knowing a right exists is completely useless if you don't know the procedure to enforce it. Double lines under this heading, please.
First up, the when. 1. On attaining puberty. 2. Within a reasonable time after puberty. 3. Before attaining 18 years under the 1939 Act. You have to clarify to the examiner that this option must be exercised promptly. It's not some open-ended right that lasts forever. If a girl reaches 18 and hasn't exercised this right, she loses her statutory protection under the 1939 Act. Next, the how. Explain these three mechanisms sequentially. Step 1. Express repudiation. This just means clearly and verbally stating refusal to accept the marriage. Step 2. Implied repudiation. This is by conduct. Think leaving the matrimonial home and refusing to live with the husband. Step 3. Through the court, by actually filing a suit for dissolution of marriage. Note this carefully on your exam. While Step 1 and 2 are perfectly valid under personal law, Step 3, getting that formal court declaration, substantially strengthens the legal validity and gives you incontrovertible proof. Write down our next heading, legal effects of exercise. A right without a legal effect is utterly meaningless in a court of law. You've got to spell out the exact consequences. Note these absolute effects. 1. The marriage becomes voidable and stands completely dissolved. 2. No marital rights or obligations continue. 3. Dower rights depend on the specific circumstances. This brilliantly illustrates the power of the doctrine, you see. The marriage doesn't just pause. The transition from voidable to completely dissolved extinguishes all mutual marital duties instantly upon valid repudiation. All right, absolute silence and attention here. Leading case law's breakdown. Don't write a single word until I tell you to. This is the section that elevates a merely average KSLU answer to an outstanding distinction level 1. First, I want you to draw this exact boxed format on your exam sheet. It forces the evaluator to see your case laws clearly. Let's do a deep breakdown. Case number 1, Abdul Qadir v. Salima. Underline that case name right now to capture the evaluator's attention. The background here hinges on the foundational nature of Muslim marriage. The final ratio decidendi, the verdict of the court, firmly established that a Muslim marriage is fundamentally a civil contract. Now, why is that absolutely relevant to our topic? Because a contract requires free consent, and a minor lacks the capacity to consent. So the law must justify a mechanism for repudiation upon majority. This case provides that exact jurisprudential justification. Case number 2, Muhammad Idris v. State of Bihar. Write this down. The facts revolve around the statutory protection of young girls. The ratio decidendi emphasized the rigid protection of minors, specifically recognizing a girl's absolute right to repudiate a marriage on attaining puberty strictly under the 1939 Act. Why does this matter? It matters because it loudly reaffirms that the courts will actively enforce Section 2(7) to protect a minor's agency, even overriding traditional parental constraints. Finally, our last heading, significance and conclusion. This is how you powerfully wrap up your legal arguments and leave a lasting impression. Consider the profound significance we have on the board. It protects minors from forced marriages. It ensures free consent after maturity. It promotes justice and fairness in matrimonial relations. Elaborate slightly in your own words here. Explain how this doctrine serves as a vital legal shield, acting as an indispensable safeguard for personal liberty in traditional family structures. And here's your final sentence. Read this concluding thought. The doctrine balances parental authority with individual freedom, ensuring a minor is not permanently bound by an unconsented marriage. I am instructing you to use those exact words to wrap up your essay. Using phraseology like balances parental authority shows the evaluator a very high level of jurisprudential maturity. So I'll leave you with this strict challenge. Have you memorized these exact headings, the specific Bare Act provisions like Section 2 VI, and the ratios of Abdul Qadir and Muhammad Idris to secure your maximum marks? If you are hesitating even for a second, you're not ready. Review your notes. Rewrite this structure until it is second nature. Master this doctrine completely before you even think about stepping into that KSLU examination hall. Class dismissed.